that reality is certainly something that seems like, well, why even bother? If it's not binding, what value do these opinions have? Well, in fact, they have great value. They are something I'll address in more detail later, but they are highly influential in identifying what the law is and what its implications for the future might be on a particular issue. So I also wanted to share how that stands in contrast to the US as one example. Many domestic legal jurisdictions do not permit advisory opinions at all. Um, so under US law in our Constitution, Article 3 of our Constitution, the judicial power is limited to what we call cases or controversies. These are real disputes between parties. So the courts in our federal system, district, appellate, and the US Supreme Court, are not authorized to issue advisory opinions. They are prohibited. So that gives you some context about how unique the advisory opinion under international law is. It's fundamentally non-binding and yet potentially very impactful. So, as I mentioned, normative weight is something advisory opinions can establish. They can express the will and understanding of the International Court of Justice on a particular issue that will influence many subsequent decision makers, whether those decision makers be courts and tribunals under international law or even at the domestic level. Many domestic courts around the world treat ICJ advisory opinions as at least having some authority. They give respectful consideration, for instance, that's the US Supreme Court's language, even though it's international law rather than their own domestic law, it still carries weight at the domestic level. But certainly at the international level, there is great respect and deference provided to the ICJ's interpretation of international law, even when it's in the form of an advisory opinion. And there's a handful of these cases that the ICJ has issued these advisory opinions, and one of them that's probably the most famous until now. This climate change advisory opinion is certainly going to be deemed the most famous in the ICJ's history. But prior to that, in 1996, the nuclear weapons case and involving it was actually the use or threat of nuclear weapons, and it was a major case that's now 30 years old that has provided authority for countries to abide by on the notion that the use of nuclear weapons is contrary to international law and armed conflict, and especially principles of international humanitarian law. So the opinion to conduct negotiations to engage in disarmament of those weapons. So now we're looking at advisory opinions in the climate change context. Why are they so popular lately? Well, there's been great frustration about the pace of international climate change governance. We have been at it now 4 decades. The original climate change treaty in 1992, the UN Framework Convention on Climate Change, showed some promise, and then in 1997 we had the Kyoto Protocol, which was the implementing agreement to that framework treaty on climate change. And so the Kyoto Protocol had a fair amount of ambition about climate mitigation, and it certainly made significant progress. The biggest problem with the Kyoto Protocol's ultimate impact, though, was that many leading emitters of greenhouse gases, the United States chief among them, were not participants in the Kyoto Protocol. So that really interfered with the potential success of that treaty regime. And it was really after the Kyoto Protocol expired in 2012 that the negotiations started for what we now have as the Paris Agreement. And that's where things really started to slow down and become frustrating, become much less ambitious, even though the science became clearer. The IPCC, the Intergovernmental Panel on Climate Change, was continuing to issue reports about how urgent the climate crisis was, and all the while the climate diplomacy progress slowed, that there wasn't that sense of urgency, certainly in the global north, to be more ambitious about addressing climate change. And so the US has certainly been the biggest part of the problem there in terms of the failure of leadership. And we have withdrawn twice from these major agreements, Kyoto and Paris Agreement. And other countries in the global north also have not nearly met their, what the rest of us would consider their standard of leadership as leading emitters of greenhouse gases, with that moral responsibility, certainly, and hopefully the willingness to embrace the legal responsibility to address those emission reduction expectations. But that's not been what's happened. So where do advisory opinions fit into all of that? Well, it gives us some small handle to address the climate crisis, despite that diplomatic failure to make our climate change treaty agreements work as effectively as possible. We are working against the clock. The climate science is telling us we have very limited time to be ambitious about climate change governance on a global scale. So these advisory opinions are one tool to identify what these climate change commitments, duties should be, and how they can be implemented through hopefully subsequent litigation that kind of imposes a mandate that isn't currently being felt by these nations. So the trio, as I mentioned, of these climate change advisory opinions started in May 24. The International Tribunal for the Law of the Sea, the acronym ITLOS, they issued that tribunal issued a advisory opinion in May of 24, and it addresses, and not surprisingly, the duties with respect to climate change and its impact on the oceans, and it considers the emission of carbon as a form of marine pollution. Carbon's released into the atmosphere, it settles in the oceans, it causes ocean acidification, which is a major climate change impact. So this decision is quite significant from May of 24. But the 1-2 punch, as I call it, from just last month, two of the most significant cases in history, certainly as advisory opinions and for the potential impact that they have moving forward, the Inter-American Court of Human Rights and its advisory opinion on climate change, and then the focus of today, the ICJ's advisory opinion, just 3 weeks after the Inter-American Court advisory opinion came down. So focusing now on the advisory opinion from the ICJ itself, and trying to get a sense of why it is so significant. Well, the first reason why it's so significant is because of the significance of the ICJ. It is by far the most important international court because it's the court of the UN system. So all UN members belong to the ICJ. And that stands in contrast to, for instance, the US is very selective about what international law regimes it's a party to. For instance, we are not a party to the International Criminal Court. So there may be issues of in violations of international criminal law, and the U.S. is not held to account for that because we are not members of the International Criminal Court. But the ICJ is the gold standard. All UN members are subject to the ICJ and the decisions that come out of it, at least in this persuasive capacity. Again, we've talked about binding versus persuasive or influential. So the advisory opinions certainly don't bind the U.S., but they have that persuasive value. One thing that I like to share about the significance of this opinion, and one thing that really keeps me going as someone who's in the field of climate justice, is how this ICJ opinion represents the triumph of youth climate activism. It's remarkable to think that this landmark decision that will have impact around the world, on all countries around the world, was initiated by a group of students in the South Pacific. This was a group of students from the University of South Pacific Law School, group of law students. that assembled to advance their agenda to have this advisory opinion come out of the ICJ, and they were ultimately supported by the country in which they lived, Vanuatu, a South Pacific island nation. And Vanuatu ultimately was instrumental in bringing that to the UN General Assembly, and in turn, the UN General Assembly presented this request to the ICJ in a unanimous effort to issue this advisory opinion on climate change. So this did not happen overnight, and that's one really important message here, that youth climate activism has been so stubborn and persistent because it needs to be. This is your future as young adults on this planet. That the results you want will often take a long time, and this did. This was over years, and ultimately, when you think about this impact, it is among the most impactful outcomes of all of the youth climate activism around the world. And we've seen amazing work go on with leaders such as Greta Thunberg and others. And we've seen major strategic climate cases brought around the world by youth plaintiffs. The Juliana case in the US is one example, but there are many others like that around the world, brought by youth plaintiffs. But this particular effort with youth plaintiffs securing this outcome from the ICJ is really quite remarkable. I'm just seeing some things in the chat. I want to make sure. Okay. So another example of the impact of this decision was, remarkably, it was a unanimous decision of the ICJ. So I mentioned how it was unanimously approved by the UN General Assembly to put it forward to request the opinion, but the opinion itself was unanimous, and that's only the third time in the history of the ICJ that the body has issued a unanimous opinion. So that says a lot. That really says a lot about that sense of why we have this opinion in the first place. There is a lot of consensus about how urgent the climate crisis is and what duties states have to do their best to address it. So this is a very important piece of legal decision making, even though it's non-binding. It was carefully crafted. And by that I mean, the ICJ is not going to come out in an advisory opinion and say, all of us, need to drive electric cars by tomorrow, and all of us need to power our homes by solar energy and so forth. I mean, that would be perhaps appropriate, but not realistic. And so the ICJ's opinion is carefully crafted in the sense that it does embrace kind of the mainstream thinking about what climate change is doing and how we ought to address it to the best of our abilities. But if it came across as radical, it would be ignored. And so it did advance, though, a progressive agenda in thinking about how we need to move as ambitiously as possible in our approach to addressing climate change. So yes, please continue to put questions in the chat, and that'll help me in terms of addressing your questions at the end. So in terms of the content of the decision, then, we have, as I mentioned, two parts, and they're equally significant. So we'll start with the first part, what the UN General Assembly requested of the ICJ to address what are state obligations under international law regarding protecting the climate system, and then what would the legal consequences be for states that have caused harm to the climate. So it's not surprising and appropriate that the opinion focuses much more heavily on the first of those two steps. When it comes to the actual consequences, the liability issues, that's very hard to really make progress on in the form of an advisory opinion. That's the kind of thing that's going to come next, as I'll mention. So this is a foundation. This advisory opinion kind of sets the stage for what could happen down the road in terms of cases that are brought against individual governments for their particular failure to act or action that harmed the climate, and ultimately seek remedies in those cases. And so I wanted you to be aware that that's what we've seen throughout this decade or so of strategic climate cases. The initial victories don't seem like much, but it's so important that we start with a foundation and then we build off of that foundation. So an example of that is a case in the US called Held versus Montana, where the the plaintiffs, the youth plaintiffs that brought that suit against the government of Montana, the remedy that they were seeking was not ambitious at all, really, when you think about it in terms of getting results. They were seeking a declaratory judgment from the court. All that means is that the court's decision will confirm that a right has been violated. And in this case, the youth plaintiffs argued that their right to a clean and healthy environment under the Montana state constitution had been violated by that government's decision to pursue a fossil fuel intensive energy mix in the state of Montana. They're very heavily reliant on coal, which is remarkable in the year 2025, but it's true. So that was the goal of the case, that the court would just conclude that this constitutional right to a clean and healthy environment does have weight and value, that for the court to recognize that that right had been violated by the government's decision to pursue coal and a very fossil fuel intensive energy mix, that could set the stage for subsequent cases where they're looking to get some kind of concrete damage or injunctive relief from the state for its action or inaction. So very similar to what we're seeing with this ICJ advisory opinion. There's only so much it can accomplish in its initial formulation. It's how it's going to be used in subsequent cases that will really determine its ultimate success. So in looking at that first part of the opinion regarding states' obligations, there's a lot of really important content that comes out of the case. The first being that, not surprisingly, the U.S. continuing to be an impediment to advancements on climate change regulation on a global level. It was joined by other states who were arguing that, okay, we've got the Paris Agreement. And the argument is that, and this is known as lex specialis. It's a Roman term that in international law means that if you've got a particular instrument of international law, like the Paris Agreement, that says you have to do something about something here, climate change regulation, the argument would be that that's the extent, the limit of what you're required to do. There's something that exists that narrowly addresses your obligations, and nothing else would be relevant in determining what your commitment would be to address climate change, other than that specific agreement on climate change. The ICJ fortunately rejected that logic and stated that there are many other sources of international law that are quite relevant to addressing states' obligations to address climate change. And one of those sources of law is customary international law, which is, would require an entirely separate lecture to give you a sense of what that really means. But customary international law is something separate from treaty law, but it also binds states to the extent it exists. So customary international law refers to what states do, state practice, that they do in a sense that they're required by law to do so, even though there isn't a specific treaty on it. It's that understanding among states that law requires us to behave in this way. So it's very amorphous, but still a very potent source of international law. And then the law of the sea, in the ITLOS advisory opinion, the ICJ confirmed that well beyond the borders of the Paris Agreement, the law of the sea and the ITLOS advisory opinion, those are relevant obligations that states have with respect to climate change. And highly important, human rights law. And this has been a growing piece of what it means to address your obligations regarding climate change impacts. The impacts on human rights that flow from climate change impacts have been widely recognized as very much a part of what states need to be attentive to and regulate. And also significantly, the ICJ rejected, again, arguments led by the US and other states regarding the interpretation of the Paris Agreement's mandates. And so this is something I'm going to go into a bit more now regarding the central agreement that came out of the Paris Agreement is this idea of each country is individually responsible for determining how they're going to address climate change. and that is known as nationally determined contributions. So, in the ICJ's opinion, there's a great step forward because there was some uncertainty in interpreting what these nationally determined contributions, the NDCs, what it really means. How much of an obligation does it put on states? And here, um, the one side, the US and others argument side, was that they really have unlimited discretion to draft and implement their NDCs. And that could be very, very low ambition, as you might expect, for countries that are not committed to the urgency of the climate crisis. They can just draft NDCs in a very meaningless way. It's just words on the paper. They're not applying the appropriate ambition to address this crisis. And that would be okay. Their argument would be there's nothing in the Paris Agreement that makes us accountable to do more than just lip service to address climate change. And the ICJ rejected that interpretation as well, fortunately. And it really raised the bar with these 2 points here. In its interpretation of Article 4 and what NDCs mean, it had great language here about countries must, states must put forward NDCs that represent the highest possible ambition to achieve the goal of the agreement. That's quite powerful. And then, even more important, using best efforts to implement those NDCs that represent the highest possible ambition. And so it's important to keep in mind, what goal are they referring to when we say achieve the goal of the agreement? Well, the goal of the agreement, quite clearly in the text of the Paris Agreement, is to limit global warming to 1.5 degrees Celsius above pre-industrial levels. That's a very ambitious goal. In fact, in 2024, we already exceeded that. We were at 1.6 in 2024. So this is how science confirms the urgency of this goal. We need to turn the clock back. We need to get levels of greenhouse gas emissions down to where we were 100 years ago, pretty much, if we want to be safe. And we need to do it in a very short time horizon to be able to ensure that global warming is at this 1.5 degrees Celsius level or below. And what's so magic about 1.5? Well, the Intergovernmental Panel on Climate Change determined that when we go above this, we start to approach climate tipping points, which basically will unravel a lot of the integrity of the climate system, which we're starting to see, frankly, if you watch the news. Rampant wildfires, floods, hurricanes, food and water security happening all over the world because of climate change. And this is only going to get worse. And the problem is when we get above 1.5, too far above 1.5, there's really nothing we can do about it. We're simply bracing for impacts. So the IPCC told us that we had about a decade a few years ago in its most recent report. We had about a decade to engage in very ambitious climate mitigation measures to at least postpone those climate tipping points where we just have to sit back and hope for the best, but expect the worst. So that's very important that the ICJ's opinion does give some teeth to these NDCs and raise the ambition of states' obligations. And similarly, this is setting a foundation, as I said earlier, for subsequent litigation. So we've seen some of this kind of litigation prior to this decision, 10 years ago even. The famous Urgenda case in the Netherlands was a domestic law case that was interpreting the government of the Netherlands' obligations that it needed to fulfill under the Kyoto Protocol. I'm sorry, under the Paris Agreement. So the Paris Agreement had just been drafted in 2015, and this case was filed shortly thereafter. The Netherlands had a very low ambition approach, although it was completely in compliance with the terms of the Paris Agreement. It was very much at the low end, particularly as compared to its European allies. It was more ambitious than the US, but that's an incredibly low standard, doing nothing. But this case was remarkable because it was successful in saying that even though the Netherlands government was technically in compliance with its commitments under the Paris Agreement, it needed to do better. And there were really effective creative arguments using climate science, using international human rights, using the civil law of the Netherlands to make the argument that the government had a duty to do more. So now that we have the ICJ advisory opinion, that's more fuel for that fire. It gives this foundation of saying the ICJ said this in terms of what states ought to do. And based on what you're doing, your interpretation of the Paris Agreement, it's not good enough. And we're going to compel you to do more. So really, that's the initial excitement about this opinion, is that it's going to make cases like Urgenda succeed much more readily around the world when these cases are brought in domestic court, applying the ICJ advisory opinion in which interprets what states' obligations are under the Paris Agreement. So what's really powerful here is that you take a laggard state like the US not doing anything on climate change, and the ICJ's advisory opinion says that customary international law also requires states to make their best effort to avoid significant harm from climate change. So even the US, which has withdrawn from the Paris Agreement, arguably still has obligations to mitigate and adapt to climate change, including an effort to engage in international cooperation on this because of the effect of customary international law. So that's quite powerful. And then human rights is really where most of the action has been in strategic climate litigation. And that's where it's very telling here, where the court embraces the human rights dimensions of climate change and states' obligations to take those necessary measures to protect the climate. And most of the successful climate litigation has been in that human rights and constitutional rights space around the world, both in international and domestic court settings. And this advisory opinion will really help propel those efforts, help them be more successful moving forward. And then we also had 3 years ago a recognition from the UN General Assembly of a human right to a clean, healthy, and sustainable environment. And the ICJ opinion also embraced that as inherent in and essential for the enjoyment of human rights. So that's also additional leverage to see some productive future results on the human rights dimensions of climate change in subsequent cases. So part two, as I mentioned, not as full and robust as part one, for good reason. These are the outcomes, the consequences that we're going to see in subsequent cases, but there's still some good language in this part of the opinion. So we saw a lot of arguments in domestic courts on this point, and the ICJ was emphatic and very helpfully so, that climate change is a global problem, and you don't have to be the sole cause of a global problem to be globally to be accountable for your contribution to that global problem. So this language from the legal consequences part of the opinion is quite powerful, that it talks about the steps that a state could take but fails to take. And like we saw in the Montana case, if you're pursuing an energy system in your jurisdiction that is fossil fuel intensive, you're making steps toward exacerbating the climate crisis by your decisions. That could constitute an internationally wrongful act, which would be attributable to you as the state and its impact on the global climate crisis, so that you could be liable for that inappropriate action of moving us away from a solution by engaging, entrenching in a fossil fuel energy supply rather than transitioning to clean and renewable. So that's really quite powerful about potential state responsibility moving forward. And we also see references to the body of state responsibility doctrine under international law, which is helpful because that really gives us an opportunity to see a full scope of remedies that might come when a determination is made that a state has violated international law on climate change duties. What does that get us? Well, it could get us an opportunity to compel that state to do something more. It could involve money damages. There are a lot of different opportunities under the state responsibility doctrine under international law. So the wait and see part, and this is what lies in store in the years ahead, those The idea that if there's a particular breach of an obligation described in part one of the opinion, that is certainly something that's potentially actionable. We just don't know to what degree. But the court avoided the additional question of whether states could be liable for climate harm, even though they didn't violate any of those legal obligations articulated in part one of the opinion. There still might be other ways states could be liable for climate change failures in terms of their failure to regulate something adequately that caused damage. There may be opportunities there to say that they are nonetheless responsible, and that's for future courts to decide. So the other significant dimensions would be the ITLOS advisory opinion is referenced and incorporated into the ICJ's opinion, and one important dimension of that is the reference to sea level rise in small island states. That was certainly a concern of Vanuatu, bringing this request for the advisory opinion on behalf of the youth group of law students. So this proposition that when sea level rise overcomes an island state, so it's just now completely underwater, there are lots of efforts now in the courts among scholars to try to say that that state, even though its territory is completely underwater, it might still exist under the UN system. It can still be recognized as a sovereign entity, even though its physical territory is underwater. So that is something that the opinion references and supports in principle. It doesn't reach a concrete conclusion about it, but that's a very important discussion to come out of a very high level opinion like this one. And perhaps most importantly, the court is just very realistic and aware of the nature of the climate crisis. In this final paragraph of the decision, talking about we're not going to save ourselves from climate change one advisory opinion or one court decision at a time. We have to do much better than that. There's really a limited role for the courts and for international law, for that matter, to address this existential problem of planetary proportions known as climate change that imperils all forms of life and the health of our planet. So this quote at the very end is really quite telling in that we have to remember that this is just one small tool in a much larger toolbox. How we as a global community are going to address climate change effectively goes well beyond what the courts and international law can do, goes well beyond what even domestic law can do. It is about individual decisions of everybody across the global north and global south. Everything we do as residents of this planet can be less impactful and collectively good for the planet's health and the health of humans inhabiting the planet. And so we have to be thinking about the climate crisis in that manner, that we all are a part of this, and we can't just rely on sources of international law, strategic climate litigation to say, here's the way we're going to resolve this crisis, because it's much, much larger than that. And we have to remember that. And the decision is quite powerful in recognizing that reality. So I thank you very much for your attention, and I'm happy to entertain your questions and discussion.
All right. Thank you so much, Professor, for that wonderful presentation. I believe we are so much impacted. To proceed with the questions, I wish to request that we should jot down the questions. For those that ask questions to ask, we should jot down the questions so that after the second speaker have taken the presentation, we can now proceed to save our time. So at this point, I wish to invite the second speaker, in person of Mr. Pedro Edouan. I don't know if I'm pronouncing it correctly. Mr. Pedro Edouan is a legal professional with a robust academic professional background in energy, environmental, and corporate law. And he served in the legal department of the Ministry of Environmental of Angola, where where he advised on environmental legislation, contract drafting, and legal due diligence. He also bagged a master's degree of laws in environmental and energy law from Georgetown University Law Center. So permit me to welcome a second speaker, Mr. Edwin Fredo. Thank you, sir. You're welcome, sir.
Thank you so much, Nachi. Good afternoon, everyone. And I'm Edwin Pedro, and I will focus on the oil and gas implication of this decision. First of all, I would like to appreciate the organization for the invitation, and congrats, Professor Randall, for the amazing presentation. I didn't expect less from him because he's literally one of the best environmental law professors. And the pressure right now is really huge. The pressure is really huge. I don't know if you are able to hear me. Are you guys able to hear me?
Very well, very well.
Okay. Yeah. I was saying the pressure is huge right now after this brilliant presentation. As I said, I would like to start with a broad implication related to the oil and gas industry upon this decision. This decision will impact so much in terms of international law and global energy governance, because the recent advisory opinion delivered by the court has sent a signal, which is the fossil fuel producers are on notice. Even though it's not a binding advisory opinion, but the user are on notice. And the implication of this opinion cannot be overstated, because the court was explicit in its reasoning. It affirmed that the relevant conduct for purpose of international responsibility is not confined to the direct act of burning fossil fuels. Rather, it encompasses all actions and even omissions of states that result in the destabilization of climate system through emissions. Basically, in simple terms, this means that fossil fuel production itself, whether to issuing exploration licenses, sorry guys. Okay, saying it simple means that fossil fuel production itself, whether through the issuing of exploration licenses, the approval of fuel extraction projects, or the granting of subsidies, all of it fails squarely within the scope of conduct that can potentially breach international law through this advisory opinion. And it is really clear that, and Professor, when we're talking about the IPCC and the Judge Bandari and Judge Cleveland in their joint declaration, they highlight this point. And basically the idea is that fossil fuel production, fossil fuel consumption, granting of exploration licenses, or other provisions of fossil fuel subsides may constitute an international wrongful act under this opinion. So I think so many countries now, they will have, I would say they will be more concerned about comply with this international law obligation, and not only focus on the economic perspective. And I think for the first, it is kind of historic, because for the first time, states that produce oil, gas, coal, they are warned about the expansion of the production. What I mean by that is that all of these countries, they would like to increase, because they by increasing their activity, by increasing their production, they will have, of course, more revenues, right? So, but the problem with this is that if they do now, they will attract more legal risk. Because of this opinion, I think the legal risk increased a lot. So right now, even though they are sovereign states, I think the choice is not only about the energy policies, but it's now about international law. They have to think about the economy, but they also need to think about their legal obligation in the international arena. And I think this whole situation facing right now, climate change, energy transition, we have basically two fundamental pillars of energy transition. The first one is to fight against greenhouse emissions. And the second one is the safeguard the right of development for the countries that they are oil and gas dependent. So right now we'll have kind of a fight between right to development through the oil and gas industry, because so many countries, including mine, I'm from Angola, by the way, we depend on oil and gas revenues, but also these same countries, they need to comply with the international law rules. So now they will have to adjust their policies in order to comply with the international law rules. And also, I think it's a great opportunity to diversify the energy portfolio. I think by investing in renewable energy sources, they can really grow economy-wise and also comply with international law obligations. And I think the advisor opinion also advanced two critical options. The first one is the environmental impact assessment for fossil fuel extraction project. They must be considered downstream combustion emissions, so-called Scope 3 emissions. The second one is that new national climate plans must address fossil fuel production, licensing, and subsidy in a manner consistent with the 1.5-degree pathway. So the question will be, what does would be or mean for fossil producing states to avoid these legal risks? And I think the best way to avoid these legal risks would be for them stop issuing new exploration licenses, stop granting development consistent for new fossil fuel projects, and adopt robust regulation without the production. I think these three options that I mentioned are the options that so many scholars recommend, but I don't think it would be really, really realistic to comply with all of them, because for oil and gas producer country, it is really, really tough to just stop exploration licenses. It's really tough. Sorry. Okay, thank you so much, Nashi. I'm about to finish. As I was saying, it's really, really tough to oil and gas producer countries, especially when they are dependent of these natural resources, just stop issuing new licenses, exploration licenses, because they need the money which come from this industry to run the country. And I think the best option would be to adjust the regulations, not to phase out like all the oil and gas production, must to decrease a little bit the production and invest in renewable energy sources. And as renewable energy increasing a lot, also the oil and gas industries are increasing a lot. I have some Professor Sempertegui, he mentioned that from now to 2045, it's possible, and according with World Oil Outlook report from OPEC, it's possible that it expects that 99 we will have the level of oil and gas consumption by 2045 will be 99 million barrels per day. And right now we are nearly 80, 82. But in those years, it will increase a lot. So we have the renewable energy industry increasing a lot, and we also have the oil and gas industry increasing a lot. So I think this decision can help is increasing a little, but not automatically. It's not gonna help like automatically. Can help this increasing a little bit because states will be more focused on no violate the international legal obligations. But for state that depends on oil and gas, they will not phase out all the exploration because they need the revenues for oil to invest in other projects, even in energy and renewable projects. So that's pretty much what that I came out with. Once again, thank you so much for the opportunity. And I'm here to share my question and answer yours. Thank you so much.
All right. Thank you. Thank you so much, Mr. Pedro, for the wonderful presentation. You actually still have 5 more minutes on which you still can proceed. Mr.
Sorry, I
Pedro,
didn't
sir.
get it.
Okay, you actually have 5 more minutes remaining to round up your presentation. All right, thank you very much. That was a wonderful one from Mr. Predu. We can welcome questions for the first speaker. Those that ask questions to our able prof, you can actually indicate with an emoji so that you can give you the room to ask your questions. If you have a question, you can actually indicate with your emoji. I want to confirm if you can hear me. Can anybody hear me?
Yeah, we can hear you.
All right. This is a section for questions and answer. If you actually have a question for the first speaker, this is the right time to ask. Initially I saw some questions in the comment section. I don't know, Mr. Ikra Paven, should I read out the questions or you give you the room to ask it yourself. Does anybody has a question to our speakers for today?
All right. I actually have a question. Okay. As it,
All right. There's a
Oh,
question from the
I'm
comment
sorry.
section.
What just happened with my Zoom?
I don't know who you are directing the question to, but there's a question from the comment section. Mr. Ikra Paven, to who are you directing the question? Is it
I think she's a lady. Any of the speakers can answer.
okay? So the question says, and for big countries, for those countries who contributed more carbon in the atmosphere, their machineries must be carbon free or use of that material in the machinery which absorb carbon from burning of a fossil. Is this actually a question? I don't know.
I think the
Mr.
second
Ikra.
the second part, the next part of that question is more of a question. Can't we reduce the carbon from these fuels during extracting and refining them? And should the big countries who are some more significant carbon emitters have to be carbon free in their use of fossil fuels? I mean, it's certainly the general effort of the climate governance community that the starting premise is that the global north has a higher obligation to address climate change regulation because it has the legacy, as the term is used, of pollution over a much longer period of time. So the global north advanced in its industrial revolutions much earlier than the global south and contributed much more to the global climate crisis as a result of their earlier industrialization. So there's a principle called common but differentiated responsibility, which means everybody, all nations have to be involved in addressing climate change, but the global north has a higher responsibility and should assist the global south in meeting its climate change responsibilities. So we're certainly seeing more pressure on the global north to transition to clean and renewable energy. And while the global south can be permitted to rely longer on traditional fossil fuels in that transition, and the global north can provide funding and technology to assist the global south in transitioning to clean and renewable energy sources, but that's going to take much longer in the global south, and the global south is entitled to rely on fossil fuels longer from an equity perspective because the global north benefited from that reliance for many decades prior to the global south's industrialization. So that's kind of, I think, embedded in the question. So I certainly welcome any additional comments that Edwani might have on that.
All right. Thank you so much, Professor. We have another question here, which says, what type of climate issues are solved in ICJ?
Well, that goes back to the reality that the courts are really a last resort to address these questions. So one limitation that I didn't address in the presentation about the ICJ as a source of addressing climate disputes is the perception that they lack the expertise on that topic. There's a general concern, even in domestic courts, that there's an insufficient expertise to address climate litigation matters, which I don't think is well founded, but it's out there. So the limitation of cases coming before the ICJ as compared to advisory opinions means that states have to agree to have their case heard before the ICJ. So it's unusual that a state that's involved in climate change non-compliance, like the US, for instance, would agree to be a party to a case before the ICJ by a state that is concerned about the impacts of climate change. So the nature of the ICJ's jurisdiction makes it difficult. It doesn't have compulsory jurisdiction over the parties the way domestic courts do. When you're sued by someone in a domestic jurisdiction, courts often have contempt power, which requires you to be in court. And if you don't show up in court, you're going to be compelled to be in court. That's not true for the ICJ's jurisdiction. So this advisory opinion is probably the best we could hope for in many ways coming out of the ICJ. There are other tribunals like the ITLOS tribunal that have addressed climate change matters in other ways. And certainly we're seeing a lot more of that in the human rights space. So the Inter-American Court has had more experience, I think, with climate rights type issues and than the ICJ.
All right, thank you. Thank you, sir. All right, thank you very much, sir. We are privileged to have a prof in our midst. You can actually ask questions that have been on your mind in regards
all right.
to.
I have a question. All right, late last year, in a decided case, I think in Netherlands court, that's Shell versus is it now mainly different sea, whereby climate injustice was really seen. So, sir, please, what is the relationship between the judgment given, late last year, which caused or which promotes climate injustice, and this, current adversary opinion? Although, based on my legal opinion, because I actually published my opinion regarding the climate injustice of last year. So what is the relationship between two I'll call it sentence now, judgment, and again the second question is, what is the better route to climate justice? What is the better route? Even beyond, or is there any route than judicial activism? I think that's 3 in 1 question.
Certainly,
I don't know
that's a good question. So one example I will give is that a lot of these cases around the world, whether they're in international, regional, or domestic courts, many of them have lost in court. And I consider that an example of losing the battle but winning the war, because what we're seeing is that a lot of these climate justice cases are raising awareness about climate justice concerns that are happening in communities around the world and in nation states. And so what has happened because of that is that we've seen a growing climate justice movement that has evolved because of the publicity that these cases have generated about climate justice problems. And we are seeing very effective outcomes outside the courts that have been quite productive. So some of them happen at the national level, although not many. But with the US as an example, at the state and local levels, we're seeing efforts that are promoting climate justice protections in ways that were not achieved in the court cases where climate justice plaintiffs did not win in court. So I think it's very important to think about climate justice as a strategic endeavor that in part happens in the courts, but it is happening at all levels of governance, certainly with advocacy from youth and small island nations, least developed nations around the world. That's happening at the UN level of diplomacy, and it's happening at legislative bodies in countries. It's happening in the courts. It's happening at the grassroots level, and it's all very important to maintain that battle on all fronts. And we're certainly gaining traction because of these efforts.
So, sir, what you mean is that they're okay. Go on, sir.
Just to point out regarding to the battle to climate change justice, I don't have the best road, but I think if we follow some principles, it can really help. And I prefer to mention one, the common but differential responsibilities. I think it's a really, really good one, and it should be in the core of this discussion. The ICJ also made a lot the human rights at the core. So this is one as well that we can focus on. And procedural justice, we can bring the idea of free, prior, and informed consent in order to have meaningful participation of community. And this distributive justice can help as well. Intergenerational equity can help as well. We have some principles that we can use as a roadmap for this climate justice road.
All right. All right. We actually have we have an interesting question from Ikra again. He said, "I am from Pakistan, and nowadays Pakistan is experiencing so much flooding due to rare cloud bursts, lake bursting, and heavy raining that all are caused by climate change, but Pakistan is contributing only 0.9% carbon in the atmosphere. Why we are facing that climate change, which we are not causing?" So question to our speakers.
Yeah, certainly that's the plight of the global South overall. That the cruel irony of climate change impacts is that those countries that have contributed the least to this global crisis are experiencing those impacts often in a way that's known as first and worst. That they are much more vulnerable to the effects of climate change, and the fact that they have not contributed significantly to those factors that cause climate change is quite unfair, and that's really where the climate justice movement has grown from. That idea of the disproportionate burdens, whether it's on communities within a nation or on a global scale, global North versus global South. There's an effort that the law is making to try to better protect vulnerable countries and communities from those impacts, and that's part of what climate adaptation law is about. Pakistan is certainly extremely vulnerable to many climate change impacts these days, and it's encouraging to see that the courts in Pakistan have been working very well in addressing climate justice matters. There's a case known as the Leghari case, Leghari. It's one of the most significant climate justice cases that was reached a favorable outcome in Pakistan. And it's one of the leading cases from around the world that happens to be in Pakistan. It was brought by a farmer in Pakistan that sued the government of Pakistan to implement the commitments it pledged to take on climate change, but failed to do so. And so you had this David and Goliath scenario where a farmer was successful in compelling the government of Pakistan to ultimately implement its climate change commitments that it had made as a government, but just hadn't gotten around to do it. So that was quite empowering. And there was another case brought by a 9-year-old girl against the Pakistani government, and that still has yet to be resolved. It was filed many years ago, but there's certainly the efforts, the awareness that is starting to happen in Pakistan, and it's encouraging to see. So I think that's something that I'm happy to discuss more about offline. I'm also happy to note that I have two LLM students in environmental law in the program I supervise from Pakistan this year, and they're very committed to address these climate justice issues in Pakistan as well. So it is about attending webinars like this, educating yourself, and trying to work in networks that can make a difference.
All right, thank you, sir, so much for your wonderful response. He went further to ask again that I want to raise my voice to the ICG to take special initiatives for Pakistan, which more vulnerable countries from few years past. What's the roadmap? It's a question. I don't know if you get the questions. Yeah.
Yes, I see the questions. So that's a very ambitious question. I mean, I think the example that I provided today, this group of law students from the University of South Pacific in Vanuatu, a tiny island nation in the South Pacific, is the reason why we have this advisory opinion on climate change today. So I think there are a lot of opportunities within academic institutions to organize in this manner that's happening in the U.S. and around the world. There's a great set of opportunities for those who want to engage in climate youth activism to ultimately join these organizations and be a part of the initiatives that they're undertaking, and they're happening all around the world. So that's very encouraging, and this is an example of how much can be achieved with the right kind of strategic efforts. So yeah, I mean that's a much larger conversation, but it is encouraging to see how much progress has been made by these types of organizations influencing climate justice outcomes around the world.
All right, Mr. Arnold Walford, your question is very lengthy. I don't know if you can unmute and speak directly so that we can hear what you're saying. Mr. Arnold, are you with us?
Yes, hello, good friends. Hello.
Yeah, we can hear you. You can
yes, I was inquiring whether Prof can just send us some document highlighting the stages and process of writing a research proposal specifically for climate justice. I want to do research on climate justice and activism. Thank you so much.
All right, thank you so much. I think there is a request to our Prof, and I believe Prof will respond to that.
Yeah, I mean that's certainly a relevant and broad-based question that I'm happy to talk more about. But as a general matter, I mean a lot of the climate justice research opportunities are in academic institutions. So my students who work under my supervision have written papers that have been published on climate justice issues. They've participated in clinics that address climate justice issues as part of their legal education. I think for those who are not in an academic setting, it's really a matter of having influence more at your country or local level, and then that's something I know less about, not living in those countries, but I know there are global networks on climate justice activism when you look online that you can be a part of. And I think that movement is really quite strong. I mean, there's a coalition of youth advocates that participate in all of the conferences of the parties for the climate change treaty negotiations. And so when I attended that annual conference, which was in Glasgow 5 years ago, there was a remarkable showing of young adults that were formally able to participate, offer their input into the international climate change treaty negotiation process and implementation process. So I think it's important to be able to seek out that information in your own country about how there is an avenue for participation in that process, because that's the way you could have impact on a global level, not just at the national level. And then it's the political process for you to have that impact at the national or state or local level in the country where you live. And that's very much like any other political issue, trying to have influence on what happens at a policy level with the politicians that affect issues in your day-to-day lives and where you live. So climate is one of many issues you could be raising in that capacity. So yeah, I mean, and there's lots of literature out there on this issue that has been, just happening at a growing rate over the past decade on climate justice awareness. So I'm glad that this Climate Justice Awareness Network is doing its part to promote that awareness. And there are just many, many resources online on this front, podcasts and blogs and webinars to participate in.
All right, Professor, someone said Ghana is heavily reliant on the fossil fuels, with oil exploration expanding in recent years. What roles does the ruling play in accelerating Ghana transition to renewable energy while balancing economic development needs?
I think that's more a question for Adwani, maybe.
Ghana, I think Ghana has discovered and developed offshore oil reserves as, I don't know if I'm pronouncing it well, but Jubilee and Sankofa, and all of them are really important for the country, and it can really help when it's come to finance other projects with the oil and gas money, right? But meanwhile, they have these oil and gas reserves. This is a wealth, of course, but Ghana also is vulnerable to climate change impacts, such as rising sea levels, coastal horizon flooding, and all of that. So the best way to deal with it would be keep exploring, but use the revenue from they should create a strategy, oil and gas strategy, 5-10 years. And then during these 5-10 years, invest as much as they can in order to the next decade, they only focus on renewables. So that's a great way to do this if they are not depending on the oil and gas to run the whole country. So I would suggest to make some regulations, legal and policies regulations, in order to explore more the gas industry for 5-10 years, and then use this money to invest in technology for renewable energy projects like solar energy, wind, and hydro projects. That's pretty much it.
All right. Milano said, apart from managing their own environmental impacts, are developed countries required under global agreements to help developing nations shift towards renewable energy sources? Uh,
Um,
did you
Professor,
you
can I
you
help with this? I think. Oh, sorry.
okay, Mr.
Okay.
Milano, can you ask the question directly?
I think the question is regarding the
Yeah,
finance
I
of
mean
renewable
that's something
project.
that I can address that
Yeah,
I mentioned before about the common but differentiated responsibilities that there are
exactly.
there are commitments in the terms of the initially the Kyoto Protocol, which was the predecessor for the Paris Agreement, the idea that there is supposed to be leadership in the global north to provide funding and provide technology transfer to help developing nations shift toward renewable energy sources. And that has not been going as well as planned. There's been a failure of leadership in the global north in terms of providing adequate funding for that both aspects of addressing climate change in the global south, climate mitigation efforts and also climate adaptation efforts. And there was some limited success with what was known as the Clean Development Mechanism, where there'd be partnerships between a global North nation and a global South nation to build projects on clean and renewable energy in the global South. And that was part of the Kyoto Protocol. These days, the focus is much more on adaptation, and even there, we're seeing failure in the global North to provide funding to sources like the Green Climate Fund, which is meant to be a source of revenue for the global South to adapt to climate change impacts. So there might be food insecurity, it might be sea level rise, it might be ocean acidification that's decimating coral reefs. And the idea is that the global North is supposed to send significant amounts of money to address those what's known as loss and damage from climate change. And that's been a big sticking point in the negotiations that the global north is not being sufficiently forthcoming with that financial support to the global south.
I have a question. Okay, Mr. Desmond. Mr. Desmond, you can unmute and speak. Mr. Desmond, we can't hear it.
Thank you very much. I think I wanted to raise concern about the youth and climate justice. For over the years, Ghana's youth population, they are doing very well and probably at the forefront of climate activism. But then I remember an incident that happened last year, I think in the middle of 2024, where a group of young activists stood up against the issue of illegal mining, popularly known as galamsey in our country. And when these people, after they had gone through some processes, they realized that their voice are not being heard. So they put themselves into demonstration. I think one of them, they went to the seat of the president, and some of them got arrested, some too were beaten up. And as at now, we've not heard anything properly from the government. And unfortunately, that the government too is not in position. Even though some of them were released, some too were beaten up. And in a case like this, how can this ruling empower youth voices in demanding government's accountability and inclusive in climate policies?
Yes, that's an excellent concern and one that I'm aware of. Actually, I had an excellent student from Ghana in my program, two of them actually, in the past 2 years. And one of them wrote this blog entry, that article that I'm sharing in the chat. It's addressing the galamsey issue in Ghana. And I mean, just at a more general level, the concern you're raising refers to protection of environmental defenders. A lot of times it's very dangerous for activists to express their concerns about environmental issues, whether it be climate change or other concerns like mining. There are international human rights agreements now that are building in measures to protect environmental defenders. Of course, it's very difficult to fully police those threats that environmental defenders face, but ultimately there's much more awareness now about protecting the efforts of environmental defenders in their initiatives to protect the environment and the climate system. So I think that's a positive development generally, but it's still very disturbing that people who are trying to do good are facing, very difficult pushback and threats to their safety and their lives.
All right, I had a network interruption. I don't know. Can you hear me?
Yeah, thank you. Thank you very much.
All right. Sorry, I'm experiencing a network challenge.
Okay.
Thank you very much. Do we have any other question? I actually have a question. What role will the international organizations and the courts can play in monitoring and enforcing compliances towards this international climate justice? I don't know if you get the question.
Yes, yes. So I think there's again very much of an all hands on deck approach here that it's not one entity or organization that is going to save us from these threats. So I think there are certainly very important roles that courts play in advancing climate justice, one case at a time, because that builds momentum for subsequent efforts in other cases in other countries. And in terms of international organizations, they play a very important role in bringing awareness to issues that need to be involved at the negotiating table through the climate change diplomacy process. So we've got all kinds of organizations that ultimately bring their views to the process of deciding how to address climate change and climate justice governance issues. So yeah, I mean, it's really like any other legal issue that you need legislative engagement, you need judicial engagement, you need executive engagement from, the president and the agencies of governments at the domestic level as well as the international level. Yeah, all of it is very important to move things forward.
Wow. Thank you very much, Professor. Like one of my profs always said, that the fight against climate change is actually a fight for everyone to embrace. It is not just a fight for a specific set of people. It is a fight for everyone because one of the greatest war the humanity is facing is a war against climate change. It's not a war against terrorism. It is not the war against banditry like we've actually facing in some other countries. But one of the greatest war we're actually facing now is the war against climate change. So hosting and organizing such programs like this will actually impact us and prepare us ahead of the challenge. We are actually the voice of the future. So we need to actually act now so that the future generation will actually have a place to stay and an earth to call a home. So thank you very much for your contributions. Yeah, I wish to request that we take a snapshot. We are going to take you can on your video so that we can take a screenshot of the attendance of everyone, of the presence of everyone. You can can switch on your video record so that we can take a snapshot before we proceed to our next item for today. Thank you. I'm still waiting for the rest. Mr. Arnold, Deborah, Lorena, Ikra, can you on your video so that we can take a snapshot, a quick one? Actually waiting.
My video is my phone is just hanging.
All right. Mrs. Deborah, are you there? We want to take a quick one. Let's be fast. Mr. Ikra Pavian, are you there? All right, let's just take. All right, thank you very much. You can turn off the video. I've taken it already. So I wish to, for the next session, I wish to invite one of our teammates, our team, a member of the team planning, central planning committee, in person of Deborah Ifemi, for a vote of appreciation and thanks for our speakers and our audience at large. Thank you, Ms. Deborah. The floor is for you. This is Deborah. Are you there?
All right, I think she could be busy. I think she's busy. All right. I would love to appreciate everyone. Professor, thank you for sharing your Zoom room with us. Thank you very, very much. Thank you. And my brother Donny Pedro, thank you very, very much. Thank you for for such a wonderful lecture. Yeah, my Jota here so filled. Yeah, and I can't wait to actually share it with the other family regarding what I've learned so far. And Lorena, yeah, nice seeing your face. Thank you. I also appreciate everyone. I appreciate our ambassadors as well. I appreciate my team members. Sincerely, without you guys, without you all, this webinar will not hold. Thank you very, very much. Please, if you like to partner with us, you can just reach out to me through my Gmail. And sincerely, we really have a long way to go. Yes, in promoting climate justice, we have a long way to go. But then we so much appreciate everyone for joining. Thank you, Professor. Thank you very much. Thank you, sir.
Thank you very much for having me. It's been a pleasure. Thank you all for your questions.
Yeah, thank
Thank
you.
you so much, guys. It was a pleasure to be here.
Yeah, thank you very much, Lorena. Thank you.
Thank you very much.
All right. So, please, in case you have any question and you need, okay, I think, okay, Deborah, are you there?
It's Mr. Desmond.
Deborah.
Mr. Desmond is
Okay.
actually.
Yeah, humbly, I would be very happy that our professors will share their email with us so that if we need anything, we can email them and seek their insights. Thank you very much.
Definitely. I'll send it to you. Yeah, I'll send it to you. I have it. I'll send it to you. Our time is fast spent. So let's. Okay. You can check the chat out. All right. So thank you very much. Thank you for joining the meeting. So hoping that we share our next plan very soon. Although it might not be webinar like this, but then we hopefully have a big plan. Yeah. Thank you very, very much. Thank you, sir.
Thank you. Look
Yeah.
forward to our
Thank
next
you.
opportunity.
Thank you very much, sir, for having. We are grateful for having you. Now, we appreciate so.
My pleasure. I put my email in the chat.
All right, we'll reach out to you. All right, the section has brought us to the end of our webinar. Thank you for joining. We'll meet you soon in our next activity or series of events coming up. Thank you very much. Thank you. Bye.